Wonderful. Well, thank you again for being with us and good afternoon. Despite our overcast skies, today is a bright day for the League and our advocacy movement, which began 90 years ago by a very small group of Maryland mayors. The League was founded on the foundation of doing what is best for the majority of our cities, and we are proud as a team to continue that and to look to that mission with our success this past session. Our team does not often get the downtime they need or the recognition they deserve. So first, I'd like to begin by really genuinely commending the advocacy and public policy team of the League for the work over this last year and the last 90 days. The work done in this off session is truly the foundation of any wins we can point to and claim. So thank you to Bill, Angelica, Justin, Iris, and Tyler. You guys are awesome. We really appreciate everything you're doing on behalf of our members. So thank you. To our legislative committee members, I see quite a few on, led by Baltimore City Council Member Conway and Vice Chairs Mayor McNinch and Mayor Ashman. Thank you so much. The staff executes the position taken by the legislative committee members to the best of our ability every session. And by that, I do mean 100-hour work weeks of thinking, talking, texting, running back and forth to meetings. And I just couldn't be prouder of the work put in by our members and our staff alike. It is a great cohesive unit. The landscape this year was a fascinating one, given our fiscal challenges as a state with the structural deficit, the midterm election year, and an uncertain federal landscape. The legislature focused on larger issues such as redistricting, the energy costs, immigration challenges, in addition to trying to balance a budget. The leadership between the two chambers and the governor has been off and on tense. Oh, and then to add in a special session we had the week before Christmas, just to elect a new speaker. We had our hands full before the gavel even was presented, or much less came down this year. I'd like to kick off today with a focus on our legislative priority. Last year, member municipalities submitted over 20 legislative action requests, and 17 of those were connected to expanding revenue. Having had quite a bit of unexpected success last year in our prior session for our revenue bill, we learned a lesson. And the lesson was the budget in 2026 was not going to be the year we did solutions. We're not going to add fees and taxes. It wouldn't be a debate. It will be the focus for the 2027 session. The last time local government revenue was ever looked at was in 1962 by the state. Income tax was actually one of the solutions that came out of that study. With the House Ways and Means Chair Wilkins and our new speaker and former College Park municipal official giving us her nod and strategic guidance, we had an amazing House hearing and bipartisan support off the floor. So historically, and I do see former or Mike Miller's daughter on today, she would know as well, the Senate does not consider work groups in an election year for a variety of reasons. We were able to time that advocacy day right before the crossover, and the idea of a council resolution was proposed to me by Justin and Bill. It was 3 weeks of fast and furious by our members to get these resolutions passed. And we still have them coming in, and if you haven't done it, please consider adopting a resolution. The full support will be brought to the first meeting of our new work group, along with a ton of data we've collected, the studies that we have been hiring the last few years, and any resources we're learning from other states to compare to our own local government revenues here in Maryland as the work group will begin this summer. I want to thank all of our members who ran with the idea, helped us get 30 plus resolutions in, and got the bill out of the Senate. What I do want to point out, the Senate hearing is probably one of the easiest and quickest, swiftest hearings I've ever seen. It was done in 30 seconds. I'd like to also thank Chair Gazone, who is a friend to us. He had the bill drafted in the fall, and he carried that torch on the Senate side along with Senator McCray to get it off the Senate floor. From our team, thank you to Justin, who had the lead this year. You've done an amazing job with our priorities the last few years. It has not been easy to manage that, and also the budget and all the other revenues, but I appreciate your hard work and really taking the lead with me on this. With that, the bill was one of the first signed by the governor the day after sine die, and we will be getting to work as soon as it comes to life this summer. My ultimate goal personally is to have a real proposal or answers for all of you by the 2027 session. And if it's not a priority, then we are going to put those in amendment forms because there will be other solutions being proposed and we will be a part of it. No more sitting on the sidelines, but MML will be actively pushing to be a part of all those solutions on behalf of you. So I am very excited to now turn this over to our Managing Director of Advocacy and Public Policy, Bill George, and his team.
Great, thank you. Thank you so much, Teresa, and this excellent background on the session and our priority bill. This is the third priority bill that MML's passed in the last 4 years. It's been an impressive run, and I'm really happy to be a part of it. Let's move on to the next slide. So just quickly, session by the numbers. You can see here the number of bills introduced, the number of bills reviewed. That was by our legislative committee. MML staff takes a look at all the bills that are introduced and curates a list of the bills that have municipal impact to present to the legislative committee made up of municipal officials from across the state. Of those 266 that were reviewed by the committee, 187 positions were taken. You can see the breakdown on support with amendment, opposed and informational. Those are terms that are used by the General Assembly for the type of testimony that interest groups can submit. And then the last piece is fiscal note requests, 347. Last year, we saw a massive uptick in the number of fiscal note requests that we received from the Department of Legislative Services. So for each bill that's introduced, the department, a nonpartisan arm of the legislature, writes up a fiscal and policy note for each bill that summarizes it, talks a little bit about some of the changes, the current law, and then also the fiscal impact on the state and local governments. So we receive at the League fiscal note requests from the department to help inform their note that they provide for each bill. So I want to say prior to last year, we were somewhere in the mid 100s in terms of the number of fiscal note requests that we received. Last year, it jumped to 344, and this year we topped even that at 347. So we take the time to respond to each and every one of these. We find it a very useful tool. It's another way to kind of inform the discussion outside of the formal testimony and informal conversations we have with legislators. Is the fiscal notes carry a lot of weight with members of the General Assembly, and it's a real kind of, it's almost a privilege for us to receive such a high number because they think that we have something important to say on those bills, and a lot of times we do. So while it is a big responsibility, it comes with some serious benefits to the League and its members as well. All right, so quickly onto my portfolio. Again, I'm Bill George, I'm the Managing Director. This is my first year in that role. It's been a fascinating perspective to see the team in action, and it's been a real honor and privilege to work with every single one of them. My portfolio in terms of legislative arena is traffic safety and transportation policy, as well as personnel. That's kind of employee benefits types of bills, as well as public facilities and public spaces. We're talking kind of those are where the state tries to institute a mandate on things that need to be publicly accessible in public buildings. So we'll start you off with a speed camera bill, House Bill 55, Senate Bill 45. MML supported this bill. I was asked to be on the sponsor panel in both the House and Senate chamber committee hearings. Currently, only 3 counties and the municipalities in those counties are authorized to place speed cameras in residential districts. That is Anne Arundel, Montgomery, and Prince George's. Those were authorized individually by the legislature. This bill sought to take that authority statewide. And we've heard from some of our smaller municipalities in particular that this would be a real benefit because in addition to some residential districts, most speed cameras are placed within school zones, which are half mile around a school and the roadways there. So if you don't have a school in your jurisdiction and you're outside of those 3 counties, then there's no way to use this tried and true traffic safety device. So we supported it. The bill had a great sponsor line in the House, Vice Chair Michelle Guyton. The bill flew out of the House and had a last minute resurgence in the Senate where it made it all the way out of committee on to pass second reader on the Senate floor on sine die, but simply ran out of time. It needed just one more procedural vote to become to be sent to the governor's desk, and it didn't quite meet it. So the momentum is there to make a push for this next year, possibly. We'll be sure to reconnect with the bill sponsors in the interim about their thoughts on this going forward. Next slide, please. Okay, so next up is House Bill 188 and Senate Bill 3. We've seen variations of this bill in years past. This is an attempt to update the state's unemployment insurance framework. So long story short, the formula is calculating how much is paid into the unemployment insurance trust fund and how much is paid out in weekly benefits have not been updated in 15 years or so. So the bill altered all of the formulas that go into calculating both payments as well as benefits. So from the municipal government perspective, I know that most of our members are what's dubbed as reimbursing employers. So this is a little bit different from the private sector, who their liability for the unemployment insurance trust fund is based off of the taxable wage base, and they provide regular payments into the trust fund regardless of any claims that are made from former employees. Municipal governments, county governments as well, and a lot of nonprofits operate in a different manner in that they only pay into the trust fund when there is essentially an invoice sent as a result of a successful claim from a former employee. So unlike the private businesses whose liability is tied to the taxable wage base and regular payments, municipal governments' liability is tied to the weekly benefit amount. And this is an important distinction, as we see in some of these bills that there's a ramp up period for a phase in of the taxable wage base increase to give private businesses a little bit of a ramp in terms of how much their liability will increase. But what we've seen is that there's been no real ramp for weekly benefit increase. And while completely understand that there's a need to or a desire to have this public benefit kind of catch up with the monetary times, there's also what's getting lost in the conversation a lot is the fact that a lot of employers within the state are tied to that weekly benefit amount. So long story short, this bill ended up not receiving a vote in either committee. We're in constant contact with our partners in the business community on this. And this is one of the things that we very much anticipate coming back, if not next year, in future years. All right, my last bill for you this afternoon is House Bill 335, Senate Bill 258. This is something new that we saw this year and is based on a patchwork of case law. MML opposed the bill, and we'll get to why in just a second. So this has to do with how private roads are integrated into the public roadway network via a transfer of ownership. Going into this, I was brought up to speed quickly that there are multiple ways in which this transaction can occur. One is very, it is very transparent in that there is an offer, there's a written agreement, there are terms and conditions, kind of like purchasing any sort of other property. But then the case law goes on to say that there are other ways for a roadway, private roadway, to be offered to a local government, and separately ways in which that local government accepts it without necessarily a formal action taken. So for instance, this bill tries to codify an instance where neither party actually makes any sort of affirmative action to make this transfer happen. So what it would do is it sought to say that if a roadway has been open to the public for 20 years or more, then an offer by that private roadway owner has been made to the public, the local government, an offer's been made. Okay, but now if a local government or the state for that matter has been doing maintenance or repair on that roadway before or after the offer, then that is essentially deemed an acceptance of that offer. So this would have codified a scenario in which neither the private roadway owner nor the local government makes an affirmative action to formalize this transaction, and the private roadway is now part of the public roadway network. There are all sorts of potential problems with this, liability, just maintaining the road, integrating into the network. There's a lot more that goes into it, obviously, than just filling a pothole once over the course of 20 years. And all of a sudden the roadway is yours. You have to upgrade the street lighting, the sidewalks, the tree trimming around the roadway corners. So anyway, long story short, this bill did not pass, didn't receive a vote in either committee. In fact, there was a little bit of momentum in the Senate to actually codify that an affirmative action would be needed to be taken by both parties in order to make this type of transaction happen. So something we may look at going forward is formalizing this process. But as of now, we're still relying on the case law, and this bill did end up failing. I'm happy to take any questions as we go along, but that's the end of my portion of the presentation, and I'm happy to pass it off to my colleague, Angelica. Or excuse me, Justin.
Yes.
Justin.
All right. Looks like I'm up. Good afternoon, everyone. Justin Fiore here, part of the advocacy team. My portfolio includes government operations, so think Open Meetings Act, Public Information Act, local government processes and intergovernmental relations, so annexation, incorporation. I deal with everything on the taxation front, the economic development, business regulation, and I also have the state budget in my portfolio, which is where we will start today, since Teresa's already covered our priority. So with state budget, the General Assembly balanced a $1.5 billion deficit. And as Teresa mentioned, they did that this year without raising any taxes or fees. And what does that kind of look like? It's about $900 million in combination of agency cuts and reducing operating expenses. There are also a couple of big fund transfers that happened, including from the Strategic Energy Investment Fund, the Rainy Day Fund, and a shift from the capital budget, as well as some intergovernmental cost shifting that mostly happened on the county side. So I would say we were held pretty harmless overall in this year's budget. When you look at highway user revenue, police aid, and program open space, all of those were fully funded, as was community parks and playgrounds. So despite being a bit of a challenging year, I think the voice of our membership has been strong enough over the years on these key issues that the General Assembly and the governor collectively sought to protect these important funds for us. So relatively decent budget year for us this year. Who knows exactly what next year looks like, because we're anticipating another $3 billion deficit. So part of the work of our task force is maybe how we can help ourselves, but it'll be another difficult year to protect our own existing state resources, I think. On the next slide, I have a couple of updates on annexation related bills for you. The first one, House Bill 99. This was something that's been a legislative action request for MML the past few years, and we're really hoping to see some movement. What it does is it changes the 5-year rule and what we would call substantially different development. Right now, if a municipality annexes a property and wants to increase the density and use of that land, they need permission from the county. But the benchmark is it a higher use and density than the county's zoning? What this bill would say is it a higher use and density than what's in our comprehensive plans, which have municipal growth elements that look towards, what do we actually want to use this land with in the future? So counties are involved in that planning process, municipalities, obviously. So we all know that this is an area that could be annexed. It's just once we do so, if we've already planned to develop it, we shouldn't be running into these kind of roadblocks for 5 years. That was the thought behind the bill. The bill went to the Government, Labor, and Elections Committee, which was the newly created House committee this year. So it's the first time they've seen it. Unfortunately, it did not get any movement. The other bill I'm flagging for you here is House Bill 1178. This bill, as it was introduced, required consent from various political parties in order to annex land. So if you are going to go from one state legislative district, maybe your municipality is on the border of that. I think Frederick or Hagerstown were both kind of brought up in some of the conversations on this, is a lot of their border is on a state delegation boundary. The bill said if you cross over that, you annex on the other side of that political boundary, then you need to have the consent of that delegation. We pointed out some of the clear concerns and flaws in this process, and ultimately this was changed to just be a notification bill, which you already, whenever you're annexing, you notify the county, you notify any state and regional planning office. So now we'll just have an additional requirement to notify your state delegation or the delegation that you're annexing into that the annexation is underway. And that is all I have pending questions. Now I'll hand it over to Angelica.
Okay. Good afternoon, everyone. This is Angelica. I handle housing and land use stuff, public safety and corrections, government liability and the courts, and the elections portfolio. I'm going to start with housing. So as many of you may already know, the governor's administration put forth 3 bills as part of their housing package this year. 1 bill failed. The other 2 were heavily amended and passed. We're going to start with what I call the silver starter bill. So House Bill 239, Senate Bill 36. This is the first and the biggest, and it did not pass. It would have required local governments to allow smaller, more affordable starter homes, typically on reduced lot sizes and with fewer zoning constraints, in order to expand entry-level homeownership opportunities. In doing so, it shifted some of the traditional local zoning discretion towards a more standardized state-driven approach to increasing housing supply. MML was favorable with amendment. We were concerned with pretty much every provision of the bill. Lot cover minimums and maximums, setbacks, design standards, townhouse mandates, subdivisions, infrastructure considerations. We offered 9 pages worth of proposed amendments, and we were not the only ones. The first hearing on this bill went for hours with stakeholders from all sides testifying and offering suggestions for improvements. In the end, it was too big a bill and too contentious, and the General Assembly decided not to move forward with it. All right. And Bill 2 of 3, the Housing Certainty Act, House Bill 548, Senate Bill 325. This is the vesting bill. This one requires local governments to review and decide housing development applications based on the laws and zoning rules that were in place at the time a complete application is filed. So the bill's goal is to provide developers with more predictability. MML was favorable on this one as well. We offered a lot of substantive tweaks to make it more workable for local governments. We focused on notice timelines, the definition of complete application. We got some clarity on how the vesting rule would apply to phased projects. Almost all of our amendments were taken except on impact fees. So under this bill, excise taxes and impact fees for residential real estate projects can only be collected after final inspection and at no point beforehand. But if the developer does not pay the fee within a reasonable time, we can withhold the occupancy permit. So there's that. So basically, housing projects are locked in to whatever your rules are 4 or 5 years, starting at the date the complete project application was submitted. No questions. Moving on to the third, which deals with transit-oriented development. This is the last in the administration's package. This was built on a bill that in part failed last year. We were favorable with amendments this year. The bill promotes higher density mixed-use development in areas near transit. It ties in incentives and standards. It preserves some local discretion. The overall goal is to encourage housing production in transit accessible areas. There are 3 main aspects. Local government prohibitions on land use near rail transit, enterprise zones and transit-oriented developments, which I'm going to refer to as EZs and TODs, and financing. So on the local government prohibition aspect, we're talking about things like off-street parking requirements, allowing mixed-use development in residential zones that's located within half a mile of rail transit, restrictions on height, setbacks, et cetera, in very specific circumstances. And these were all much broader and harder for us in last year's version, but we worked out a lot of those kinks, and the solutions from last year were incorporated into this year's version. So this, I'll call it a prong of the bill, is fairly narrowly applied, which is good for us. The second prong of the bill deals with financing, and this is the same impact fee conversation that we had with the Housing Certainty Act. That happened here too. We tried to fight it, but in the end, the same rules apply here. We cannot collect until the end of the project. And then the third prong was enterprise zones, and this one was interesting. So the original version wanted to mandate that all TODs are EZs. That was problematic for a bunch of reasons. First, they're two different programs. They're designed to address distinct issues. But for us on the ground, EZs usually come with property tax credits. And we argued it's really not fair to impose that on us, especially when local governments get to consent in a traditional EZ, and that wasn't the case in this bill. So we successfully negotiated for local governments to be able to opt in to the EZ designation instead of it being automatic. So that's much better for us. So basically, there's more structure and expectations around how municipalities plan for development near transit, and generally pushes towards higher density and mixed use projects. But the application of it is actually fairly narrow. I'll pause there on housing stuff before I get into the next crew of bills, which deals with elections.
And if you have questions once Angelica moves on, just please put them in the chat and we will address them at the end.
All right, taking a breather and then going into election stuff. The environment around voting rights legislation was noticeably different this year. We see evolving federal actions and uncertainty. We saw it really heighten the state level interest in establishing its own framework, especially in an election year. So as a result, some of these bills had stronger momentum than they may have in the past. So we'll start with some good news. This comes from Delegate Julie Polakovich-Carr, House Bill 357. As introduced, the bill would have required municipalities to report key election dates to the State Board of Elections well in advance. That would have included regular elections and specials, and to post that information on our own websites. It also required SBE and local boards to publish centralized public-facing lists of upcoming municipal elections, and would have identified jurisdictions that failed to report. So we were favorable with amendment, but the sponsor came to us in the interim, and she was very interested in making this implementable and fair for us. So we talked about our concerns about burdensome timelines and regulating special elections. She took all of our amendments and we were able to remove our position. So as amended, the bill is much more limited. Municipalities with websites must post upcoming election information. That includes the date, the type of election, and offices on the ballot. And they have to report details about the next regular election to the state board. But special elections were excluded. And SBE's role is now focused on simply publishing a centralized list of upcoming regular municipal elections. That's it. So much more narrow and much more implementable. The next bill was a little different. House Bill 1448, Senate Bill 848. This one required municipalities to report a wide range of election bills to SBE, both before and after elections, including for special elections, on tight timelines that really didn't reflect how local elections are actually administered. We were originally favorable with amendment. We worked with the sponsors to narrow the requirements here and to better align on the timing, and we were in a good spot. But later in the process, some amendments were added that looped special elections back in, at which point we had to change our position from favorable with amendment to oppose. In the end, the bill did pass with a lot of our amendments, except for special elections. So there are now some new pre-election reporting requirements for regular elections. There are different pre-election requirements for specials, and there are some post-filing reporting requirements that are applicable to both. And most noteworthy, this bill is effective June 1 of this year. So not a ton of time, unfortunately. And then lastly, the Voting Rights Act of 2026, Senate Bill 255. We've seen different versions of this bill for the last 4 to 5 years. MML and usually MACO have always opposed simply because of the increased liability and inevitable litigation for us. And there's no evidence that this is even a problem in municipal elections. But as I said earlier, the General Assembly and the administration were very focused on passing certain bills this year, and this was one of them. So this year's version, which passed, is more narrowly tailored, which is good compared to what we've seen in the past, and that also made it more viable. So this bill establishes a new state level cause of action that allows individuals to challenge local elections that they believe dilute or impair voting rights. It also authorizes courts to award attorney's fees for prevailing plaintiffs. So all of this increases the legal and financial exposure for counties and municipalities. So it did pass. I would recommend taking a look at your election systems. Even if nothing has changed recently, it's worth understanding how your current structure could be evaluated under a vote dilution framework. Loop in your attorneys, loop in your counsel early. This is a new cause of action, so having your attorney assess potential exposure and give you advice on best practices is good. And document your decision making. If you've made any changes or you're considering making any changes, having a clear record of the rationale behind those changes could help you down the line. So that's it for me on the bulk of the stuff that my portfolio saw.
Good afternoon. My name is Tyler Bryce. So my portfolio is climate, energy, environment, public utilities. We're going to jump right on in. This session, the approach was, making sure that our stakeholders, legislators know that MML, we support a cleaner, safer Maryland, yes. But we are not going to be the sole bearer of the financial burden. And so that's how we came in for pretty much every bill. So the first bill that we see is Mason's Law that came out of the tragedy out in the Western Maryland floods. So the bill mandates that we inventory every open inlet, both public and private, and implement a plan to install safety grates. We all shared the goal of this bill, but as originally drafted, it was a massive unfunded mandate that really could have crippled our public works budgets. And we were vocal about that. So specifically, we carved out roughly 20% of the annual state flood management grant program just for municipal projects. And so in full, it's meaning now that we can forward these safety improvements using state dollars rather than local tax revenue. And then also we clarified that we won't be civilly liable for failures on private property as long as we've done our due diligence with prioritization and notification. So as a whole with this one, we turned up, I guess, a potential crisis into a funded safety program. However, we know that with all of the questions during the hearing, that this will come back on a county level. And so we're still going to monitor that because there may be some adjustments and things for us as well. Okay, so last year's PFAS bill was changed into two bills this year. So this is the bill that passed, Senate Bill 719, House Bill 925. Over the interim, we worked with the senator, delegate, stakeholders trying to come to a common ground, which was actually, they did their best, we did our best. And so this first one passed. So our key nuance with it was that we need to fight for pre-treatment authority. We were very clear with the committee that our wastewater plants do not create the PFAS, and we're merely the passive receivers of it. So we successfully pushed for that language, just making sure that it empowers us to set our own local limits and fees for these industrial users. If an industrial user is loading PFAS into our municipal system, we now have the statutory authority to charge them for that loading. So I believe that's a huge win. And so now our focus is turning a little bit more into the implementation and really still trying to fight for some timelines and some little things, but I know there's going to be something back next year for this one. But if we go to the next slide, the product ban, sorry. Well, anyway, so the other PFAS bill, I'm not sure, I will say did not pass, but I know the next year we'll be making sure that, that remediation fund is accessible for some of those cleanup costs. And we can just go on to the next bill for the street lighting investment. So this bill has been under Bill's portfolio in the past, with public utilities, Delegate Dylan Baylor. And so this bill hits us right in the utility budget. And so I know some of our Montgomery County municipalities have been meeting just on this about the street lighting. And so we stood firmly behind Dylan. We want to own our poles so we can just transition those poles to cost-saving LEDs and stop paying the high, often arbitrary rental fees, I guess as some have said. The utility companies brought out, the big boys to stop it, citing grid safety and property rights. And so the bill did not pass. But Delegate Baylor did secure a summer study designation, so we can just really look into it. I know a lot of our members have brought this up and said that this is a true issue, so we're not stopping this fight, and they didn't just kill the bill. We're going to keep fighting for this one. And next to last bill. So the bottle bill, once again, every year we support it. Gets better and better. We sit on the sponsor panel for it. So this is the 10-cent deposit system, which most believe of our membership believe that it's a common sense way to clean our streets and strengthen those local recycling markets. It didn't make it past crossover. And so we know that this bill is not going to completely just die. We know that you all are going to completely keep fighting for it. And so, over the next few months, I know that there may be a shift in sponsorship is what I'm hearing. And so we've been told that there will be some membership outreach on who this bill should be carried by, how maybe a different approach we should take with it next year. And so definitely just look out for that and just make sure that we get some responses, please, for that one. Okie doke. And this is my last bill, Legionella and waterborne disease control. This bill did not pass, unfortunately. But this bill for us was a high priority public health bill. And so it proposed a rigid chlorine residual floor that many of our older systems simply couldn't achieve without millions of capital upgrades from or as originally drafted. And so this bill was the easiest, I will say, for me to work with. We sent in a booklet, quite frankly, of amendments, and so that we could be a support with amendment, and they accepted every single one. And so we secured the waivers, we secured a requirement for MD, all of those, but the bill did end up running out of time and did not pass. We do also know that I believe it's Rory, I think Capital Strategies or Providence. We'll be bringing this bill back next year, and maybe there's definitely going to be some sponsor adjustments for that bill as well. But now they know what we want, and they're keeping our booklet in the bill for next year. So that's my portfolio.
Hello, everyone. My name is Iris Babelum. I have a portfolio of mainly technology such as artificial intelligence and data and emergency management. We're going to start out with House Bill 593, Senate Bill 42. It was a criminal law bill about critical infrastructure or public safety answering point interference. So this bill, we really like this bill, and we end up supporting it simply because it furthered the meaning of critical infrastructure to include municipal systems such as our public safety answering points, our utilities, public transportation, healthcare facilities, and even public schools. And with this allowance, it meant that municipalities would have an additional safeguard in place when prosecuting a person or people who willingly harmed or destroyed our critical infrastructure or our public safety answering points. This bill also expanded and added penalties for violations such as 10 years imprisonment and up to $50,000 in fines. The bill achieved final passage, both bills actually, and they are set to become law. And with that, I'm going to go on to my next bill. So House Bill 1239 and its counterpart, Senate Bill 825. This was a public safety critical infrastructure protection bill. We also supported this bill simply because it created critical infrastructure protection branch that would aid local agencies in securing and protecting critical infrastructure. The bill wanted better coordination and information sharing, which we readily appreciate between state and local governments. And in regards to creating the critical infrastructure protection branch, it would define critical infrastructure and include assets, systems, and networks that are vital to municipal security, economic stability, and public health. Where we supported the bill also because it added a cohesiveness to the parameters, the adaptions, and the protocols, and also added further alignment in between state, county, and municipal government. So both bills achieve final passage as well, and we're excited to see this bill become law. My next bill is House Bill 711 and its counterpart Senate Bill 504. This is a data privacy bill. It's on consumer data, public records, and message or Data Privacy Act. This bill, we were concerned about it. We sent in a letter of information. The bill seeks to stop the sale of consumer data or consumer personal data to a certain governmental unit if the controller of the data knew that it was going to be used in support of civil immigration enforcement under certain circumstances. It also expanded the definition of sensitive data and expanded the definition of the geolocation data within a radius of like 1,700 feet. We sent in a letter of information because it mentioned requiring record custodians to quote unquote take reasonable steps in regards to whether the request was made for the purpose of selling the data to certain governmental units. We were concerned with what reasonable steps meant. The language was quite vague, and it would require more or less ambiguity, I should say. We were originally against the verbiage simply because it was so ambiguous in nature, but we do realize that this perhaps could work in a favor due to its ambiguousness. For example, if a requester was to believe that they took reasonable steps by simply asking where the information was used for immigration purposes, or the custodian went through a multi-port procedure because there was no definition for reasonable steps, both the steps could be deemed reasonable. And so we're waiting for perhaps a court case in the future. If it is to occur, it would kind of define the ambiguous nature of reasonable steps, which would allow it to be amended in the future. But the bill, both bills, or the House bill, I should say, passed both chambers and is set to become law. And then my final bill was Senate Bill 632. This bill was for state elected officials, the protection of their personal information. This was a Senator West bill. We supported this bill with amendment. To speak about the bill's history, there was unfortunately a murder in Minnesota regarding a former Speaker of the House, and they were able to pull information from a website to find their address of her and her husband and their dog. So this bill went out, and it basically wanted to create specific mechanisms for current and formal state level, high level elected officials to shield the information from their families or remove their personal information from public records. It also would require local government entities to include municipalities in requests from the protected individual that would increase the municipal workload because they had a short 72-hour window for redacting and shielding records. And we just believe that this would be a bit strenuous for our record custodians and municipalities because they already have such a workload, especially because they also deal with MPIA requests and requests. It would just not be a good help for them. So we also didn't like the bill because it mentioned there was potential legal and fiscal exposure for local government entities, and they would receive penalties if they didn't comply. So we asked for a amendment in good faith to protect government entities who would make those reasonable efforts to comply, but they would accidentally fall short due to any technical or timing errors. The Senate bill passed out of the Senate, but it did not receive final passage in the House. So unfortunately, because it didn't pass, it's not going to become law. But these four bills were in my portfolio. And that is it for me.
All right. Well, thank you, everybody. And I hope that those tuning in have found this informative. Still have a few more minutes. So if you've got any questions, drop them in the chat. We'll be more than happy to answer them. I'm going to, in the meantime, talk a little bit about the legislative action request process. This is the process by which the league determines its legislative priority suite for the following year, and it's currently underway. In early April, we put out a notice that the submission window is open, along with an LAR, legislative action request, form to be completed and returned to either myself or Iris or both of us. If you got any questions first, also on the process, please feel free to reach out to one of us. We're happy to help you through the process. So the submission window for legislative action requests to be sent back to the league is open for about another month. It is May 31st is the deadline to have a completed submitted form back to the league. After which there's another month until the end of June before we need governing body approval. So we ask that in addition to submitting the completed form by the end of May, by the end of June, please indicate to us that the governing body of your municipality has adopted a resolution or taken a formal vote to submit this on behalf of the entirety of the municipality, not just the person who submitted the form specifically. So that will go on obviously until the end of June. During that time, MML staff will begin to write up and research each of the submitted LARs. This will include legislative history. This will include some information about potential stakeholders, some hurdles that the potential legislation may have along the way. This will all be done by early to mid-July, after which the new constitution of the legislative committee will begin meeting to hear these presentations from MML staff on each of the legislative action requests, and they'll begin to deliberate on recommending a priority or priorities based on those discussions. So typically the legislative committee will meet twice in late July, early August to discuss, ask questions, solicit feedback. At the end of the second meeting, the legislative committee typically takes a vote to recommend up to 4 priorities that will then go to the MML board of directors for final approval, typically in September. We've never had 4 legislative priorities in my 10 years here. As you've heard from Teresa and Justin, priorities take a lot of work. And so they're priorities for a reason, right? Just because a bill or an idea doesn't make it as an MML priority does not mean that we will completely ignore it. There will be bills introduced on that issue. And of course, as we mentioned, we'll siphon through all the bills during the General Assembly session and bring them before the Legislative Committee. Priorities are meant for a very small set of policy issues that garner not just a little bit, but a lot of extra attention from league staff and the membership at large. I forgot to mention that in between the legislative committee's vote to recommend a priority or priorities and the board vote, we typically do a webinar to present the recommended priorities to the membership at large, an opportunity to solicit feedback before the final board vote in September. So that is the legislative action request submission timeline and adoption. A couple of years ago, this timeline was moved earlier in the calendar to provide league staff with a little bit more time during the remainder of the interim to solicit bill sponsors, work with the Department of Legislative Services on drafting language to start building coalitions, get our bill pre-filed so that we have an early hearing date. And we found it actually to be really, really successful and helpful so far. So this is the updated timeline as of a couple years ago, and happy to answer any questions on this. And if not, Teresa, I think I'm gonna kick it back to you for some closing remarks.
Absolutely. A few questions in the chat, and I just want to address those. Yes, we will definitely get a wrap-up document to everybody. The team is working on it. We had to wait for DLS to get their report together to work off of. So that is being worked on right now. In the dispatch last week, there was a bill update, a shorter version of what you will find in the local magazine, which I believe was published on Friday. It is a digital version. So if you take a look at your emails and social media from Friday, you will see the longer several pages of bills. Obviously, we had several thousand, so it's hard to go through all that, but you will see the top bills that matter the most to our municipalities. And for the slideshow, we can certainly send this out as a follow-up to all the folks on the webinar and include it in on our MD community where the webinar recording will be. If you have any more questions, go ahead and throw them in there. I'm waiting impatiently to make sure I don't miss anyone. Absolutely, Doris, no problem. But this is our team here. This picture makes me laugh because Bill's head is huge and he's much taller than I am, and I'm taller in this picture. So I appreciate the team together and using 5 pictures, but I am the shortest of the group, and I am not the shortest of the group in this picture. It's funny. It makes me laugh every time I see it come up. If there's anything else we can answer, or I can make fun of myself for being short, please let me know. Our team is gonna get together this afternoon and celebrate. So we'll get those documents out to you today or tomorrow, but please give us a break a little bit. We have one person leaving the country in 2 days, another person leaving in 3 weeks, because now is the time we get the vacation. We is strong. I'll vacation some other time. But we have summer conference coming up in June. We're getting all those workshops ready. We will have a legislative wrap-up session workshop as we always do. We also have 2 other really fun legislative topics. We have our Shark Tank coming back for its 3rd year. Everyone loves the Shark Tank. And if anyone ever sees the show Hot Ones, we are going to do a Hot Ones policy style, talking about different policies, and we'll see who gets to stay and talk as they eat hotter wings by the moment. I asked for blue cheese yesterday, and I was told that was not part of the rules because I plan to participate as long as my taste buds allow me to. So we are going to have some fun this year at summer conference. We have our 90th anniversary celebration. I hope to see you all there. We only have 20 days left to register for that. And real quickly, July 30th is our policy symposium this year. And we are working on finding more funding solutions for our cities, not taxes and fees, but something outside the State House for bonding. So we're working with different providers such as lenders, other bonding institutions for low interest loans, public-private partnerships. So please hold on to July 30th for our policy day here in Annapolis, and we'll be talking about how we can help you find better funding for your cities. I think that is the most of the deadlines. Bill, when do you want the LARs back so I don't forget?
Absolutely. The deadline for the form to be sent back to the league is May 31st.
Wonderful.
And then council approval is the end of June.
Absolutely. And then if I don't forget this, if you're interested in serving on the legislative committee, we are a fun bunch. It's very serious, but really good meetings, really interesting. Forms are due by Thursday at 5 p.m. to be considered. The new president, Mayor Takesha James, gets to select the members of each committee. We do our best to make it a geographical diversity, and we have every department gets a member, as well as every district will have a member go for the committees going forward. So please consider joining us. We have a lot of fun. I see Mayor Brown on here. I bet he'd do a thumbs up if he could, because I know it's a webinar setup. But thank you all for joining us today. Have a great afternoon, and we will see you soon in June. Take care.